Yes, Mr. Tedros.
My lord, thank you. Was this mother's behaviour, conduct unreasonable or reprehensible? I say that's particularly in relation to the litigation. My lord has already identified, I think, a matter of principle that goes back in the case law to R&R. I say that in answering that question, Recorder Samuel's King's Counsel was entitled to consider his findings against the father and the litigation conduct of the father. In short, that you can't look at the mother's conduct in isolation from the wider picture of the proceedings.
Well, two wrongs don't make a right. I mean, if there had been a finding that the father had unreasonably pursued litigation in certain respects, I suppose one might be able to say it explains in some way or mitigates the mother's behaviour, but why should the overall picture affect whether or not she's acted reasonably or reprehensibly? It's all to do with personal conduct, isn't it?
My lady, what I would say is that personal conduct, when reduced to a list of behaviours or instances of behaviour, may not capture properly how to assess that conduct, including as to whether it was unreasonable or reprehensible. One has to see that conduct, that behaviour in context. And this is where in my skeleton I criticise the sharp divide, as my learned friend calls it, between quantum and principle. Not suggesting that he's simply minimised the findings against the father, but that what he's tried to do is draw a distinction between those that factor into the principle of costs and those which could only factor into the quantum. And I say with respect that that's only possible by doing a intellectual exercise of looking at them against each other and saying, well, these in this case are principal matters and or quantum matters. I accept that the appellant's case is clearly that that exercise was done wrong by the learned judge, but the criticisms that it was done at all, I do take issue with. To build on the example my lady offers, in circumstances where both parties behaved in such a way that their behaviour taken in isolation could be considered unreasonable conduct of litigation. In those circumstances, by the suggestion that, well, you have to hive off to the quantum stage, standing back to see the wood for the trees, invites further litigation in those cases. It builds it in, because you're saying to the court, in effect, you would have to make cross orders for costs and then deal with the fallout at a later stage.
What you're saying then is it's a factor that one would take into account in assessing, once the gateway was partly opened, how far it was opened. In other words, would it go to whether it should be 100%, 80%, 50%, 40%, etc.
Or indeed even zero, as in not to make a cost order at all.
Very difficult to say it should be zero if there's a finding of reprehensible conduct.
Say in circumstances where there's findings of unreasonable or reprehensible conduct the other way.
As I said, two wrongs don't make a right.
In any event, in my lady, I do say even before that exercise, before going through the gateway, we need to look at, not in isolation, but look at the wider circumstances of the case to understand whether the mother's behaviour was unreasonable.
But isn't your difficulty here that the judge didn't make this point? I mean, I could quite understand that one might say that there might be a case where for somebody to conduct their litigation in a particular way, which on the face of it was completely unreasonable, might not be considered completely unreasonable or reprehensible. because of something that had been done to them. That would convert it because you put it in context. But that's not really what the judge is saying, is it? I mean, he said it's mixed and nuanced and so forth, but he's not making the particular point, which seems to me, with respect to have some possible force in a different case or in a different judgment. Is he making that point?
My lord, I say that when he talks about the mixed and nuanced picture, that is part of what he is going to. That to understand the mother's behaviour is not as straightforward as the father in the case suggests. And that, again, formed part of his earlier consideration on that day as to next steps. So he talks about the more mixed and nuanced picture. He also talks earlier, and this is particularly the comments at paragraph 30, where he does not accept the father's criticisms of the mother's response statement, or certainly does not see them in the same light as the father does.
Well, the judge gives his reasons. He quite commendably puts them in a single paragraph. And the point that he is making more than once in that paragraph 61 is that the mother succeeded on some things and the father succeeded on other things. That's what he means by mixed and nuanced. Apparently, is it not?
My lord, I respectfully say not. That is part of it, but that in fact his reasoning goes further than that. In describing it as a mixed and nuanced picture, goes on to say that the case can be distinguished from others where costs have previously been named. And I say in distinguishing this case from those cases all requiring finding unreasonable or reprehensible litigation conduct, he was saying this case is different from them, and that the mixed and nuanced picture is part of that.
Yes.
My lords, my lady, how about 163 of the fact-finding judgment?
Paragraph.
Paragraph 163.
Yes.
A longer description by the learned judge of the nature of the relationship as painted by the messages. At the conclusion of which he says that those messages appear to him to accurately reflect what was happening. He dates this back to before the proceedings, 2020, and then continuing on.
Yes. Excuse me.
So, my lords, my lady, it's with that in mind that I invite the court to step back before analysing in isolation the mother's actions, to note that she was and has found to have been a victim of domestic abuse at the hands of this man. He lied about that. He was lying about that throughout the proceedings, up to and including him giving oral evidence to Recorder Samuels, King's Counsel.
He wasn't the only one who was lying, was he?
No, my lady, he wasn't. And my lady, I don't seek to go behind those findings. Rather, I do press upon the court to consider all of the findings rather than to focus or assess them individually, as I think I've perhaps laboured the point already.
No, but I understand it. Context and balance.
He was physically violent, found to have been physically violent to one of the children. Again, something which he denied, up to and including his giving evidence, something which the mother knew. He was making untruthful allegations of domestic abuse by the mother towards him, which he made at the very outset of the proceedings, which he maintained again up until those allegations were determined by Recorder Samuel's case. He denied pressuring this mother for sex in circumstances where the learned judge went on to make findings about him having done so. He was found to be not just pressing her for sex, but crass, hot-headed, and impulsive. With that in mind, I invite the court to reflect on it being a case where the children themselves voiced allegations about treatment at the hands of their father. It's not a case where the only evidence is what the parent is saying the children had told them. They had spoken to third-party professionals.
The effect of the judge's fact-finding is that the mother put them up to it.
My lady, this is where the intention point I know the court has in mind is, I'd say, an important distinction, and that Recorder Samuel's case, he was right to call it an important distinction. 188 of the fact-finding judgment, read together with 184. She was convinced that the father had sexually abused the children. She was not putting them up to it in the sense of, I know these are false allegations, but I want you to say them anyway.
That's hair splitting with respect. Putting them up to it is putting the idea into their heads, isn't it? Now, quite speaking for myself, I'd like some help as to what the facts are that led, or what the fact findings are by the judge that led him to come to the conclusion in the first sentence at 184. Because I've scoured this judgment and I can't find anything as to how he came to the conclusion that she had convinced herself of these things, and to square that with all the other findings that he made about what she was doing.
My lady, what I confined as I am to the text of Recorder Samuel's judgment, there is the fact of the children's allegations themselves. There's to some extent the corroboration by the father's behaviour towards her and towards the second child, the kicking violently, a man who loses his temper, for whom he says in messages to the mother, sex is my thing. There's corroboration in his lying materially to the police about sharing a bed, particularly with the two older children, something which the judge was not impressed about in the father's evidence before him.
when you say the children's allegations, what in particular are you referring to?
The child sexual abuse allegations, my lord.
But, I mean, take us, for example, in the fact-finding judgment to the allegation that you have in mind when you're
So the
submission.
The eldest child's allegations, as recounted by the judge, begin at paragraph 104. There's some earlier discussion of the allegations made.
Sorry, I'm just catching up. Are you on page 104?
No, forgive me, paragraph 104, 134, page 134.
Thank you.
I hope I have the same bundle pagination.
And paragraph number?
104.
That is joining the chronology at a midpoint, isn't it? Are you referring then to the allegations as being the allegations as made in the ABE interview?
Yes. Well, and there were earlier allegations made in May, as my lord identified this morning.
I'll look at the first couple of sentences of 102 in relation to earlier allegations of a different child.
My lady, I acknowledge what's written there. What I say, or what I will in due course say, is that the finding on intention, on a genuine belief, is an important factor which colours the mother's behaviour, and the behaviour not just there but at 1.8.
I see why you say that. What I'm struggling to find is where that finding came from and how to square it with all the other findings about the mother's behaviour, because at the moment I've not been able to find anything in this judgment that suggests anything other than that she put them up to it.
My lady, that's a starting point. My understanding is that there's been no appeal or application to appeal against the findings that Recorder Samuels Casey made in this fact-finding judgment. And if there were an appeal on the facts, then the bundle and the considerations may well need to be much wider than when being asked to consider the discrete issue of the costs that have arisen.
Well, that's a very fair point, but the trouble is that that finding has to be squared in some way with all the other findings which he doesn't mention or weigh up against it in the relevant paragraphs that we're looking at, 184 to 185. At no stage do we find a balancing of all of the things that he says at 184 with what he's already found.
My lady, I'm conscious that in order to answer the question, I would have to embark on submissions about evidence beyond what is contained in the bundle and what is in the four corners of this judgment.
Right.
About the mother's case and submissions in respect of medical records, medical evidence that was available. And so doing the best I can within the four corners of this document, as I point to what Recorder Samuels identifies as potential corroboration of the allegation and the fact of the children making allegations against the father. The earliest conversations the children had with the children had conversations with professionals going back to April of 2022. That was with social services in particular. You have those referred to in the judgment from 88, the evidence of the social worker who attended.
Yes.
Except that the children's comments as reflected in the ABE evidence come later than that. The criticisms of the mother in placing these allegations before the court, putting her cases to their determination, I do say, with respect, must bear in mind that the children themselves had made and said very serious things about their treatment at the hands of their father.
Paragraph 90. Italicized paragraph.
My lord. Again, I have to acknowledge that this is the evidence of the social worker.
Well, it's actually what the child said.
Indeed, my lord, give me the evidence of the social worker as to what the child said to them and the admission from the mother, and that reads to the social worker. My lords, my lady, I acknowledge as I must that the way in which this mother responded to the allegations or to her concerns about the father's behaviour towards the children left a lot wanting. That's been set out clearly by Recorder Samuels, King's Counsel. And that indeed forms the basis for the ongoing welfare interventions with the family by the local authority. There is a question remaining as to whether it is conduct of the litigation and I say again, that is also an important distinction.
Yes.
Returning, if I might, at this stage to 184.
Yes.
And the point that the finding on intention colours, must colour with respect to the mother's behaviour. I'm grateful that my lady indicated that the court has the point.
Yes.
Pressing for professionals to accept a parent's perspective and act accordingly could in the abstract be quite a positive step for a parent to take if their perspective were correct. Redoubling efforts when a parent's perspective is not initially seen by those professionals, again, could in the abstract be a positive step. What determines whether it is or isn't is whether the perspective is ultimately correct.
Not whether it's genuine.
suppose I clumsily make the point, my lady, that if her pressing relentlessly was intentional, it was because of a genuinely held belief that her children had been abused. As was, I think, identified in the written submissions before Recorder Samuel's King's Counsel, costs being awarded following a fact-finding proceeding against a parent who genuinely believes the allegations that they put forward could, with respect, have a chilling effect on allegations or concerns being raised with the court. Before leaving this point, if I might also, forgive me again if labouring a point in the skeleton, the father's case, which we have recorded at paragraph 5 of the fact-finding judgment, was that the mother had intentionally alienated the children. And in my learned friend's documents, he describes this alienation allegation as intrinsically linked to the sexual abuse allegations.
You say that the finding at 188 doesn't go that far.
I do, my lady. And that in particular, the learned judge, in describing the behaviour as that which had the potential or intention, specifically left open, and particularly when read with the first sentence of 184, that the alienation was not intentional.
What's the word intention doing in at 188 then, if he's not wanting to find that it's a possible explanation?
Except, my lady, the learned judge has included it as a part of that finding, but it doesn't bring with it that it was intentional, rather that it's a possibility.
I don't see why you can't have an intention to undermine or destroy the relationship on the basis that you think it's an unhealthy relationship because of the way that the father's behaving towards the children.
I respectfully suggest, my lady, that in those circumstances the intention is to respond appropriately to concerns genuinely held about the abuse of your child.
Thank you. Yes.
Forgive me if cheap points, my lords, my lady. There's no positive finding in the judgment that the mother instructed the children to make false allegations. That must be wherein clearly the judge did not think the mother believed herself that the sexual abuse allegations were false.
What's the situation if somebody recklessly makes allegations? You want to achieve a certain outcome from proceedings which happen to involve children, and you just go about making excruciating allegations recklessly.
My lord,
How does that fit?
I would say, first of all, that's not the circumstances of this case. That the mother had a genuine belief that the recklessness of making allegations, speaking hypothetically, of course, would include some ambivalence about whether the allegations were true or not. I don't believe that they're false. I don't believe that they're true. I don't much care. I shall make them anyway. But that's not the circumstances of this case. The mother was not.
No, that wasn't
No,
what
I
I
am
was
grateful,
asking.
my lord.
Is that capable of being reprehensible behaviour?
I'm more capable than putting allegations forward that are genuinely believed by the person making the allegations. I would have to concede that, my lord. But making such allegations
Keep
without...
introducing the word genuine, which is your word, not the judge's. Is it not?
It's a word that he comes back to in his judgment on costs.
Helpful.
Well, also, I think we can pray and aid the second sentence of 184, secure in her belief. The central
I had that in mind, and what I was touching on was the description of the belief as being a genuine belief, as opposed to a self-taught belief. Anyhow, it's in the cost judgment.
My lord, I'd have to revisit that cost judgment before saying for certain one way or the other.
I don't find it
No.
there, but something we can add to.
I think the way it's
Right.
put is at 61 subparagraph 4.
Yes.
That it was not that she had maintained allegations which she knew to be wholly false.
So at some point
Yes.
along the way, she has convinced herself. That's what the judge says in subparagraph 4.
My lord.
Yes.
My lords, my ladies, so I invite the court to step back with all that in mind and say that accounting for the father's own behaviour, his own conduct of the litigation about the points about his behaviour and his allegations against the mother in respect of her behaviour, which were found to be untrue.
Yes.
Also, when accounting for the inquisitorial nature of the children proceedings, a point clearly in Recorder Samuel's King's Counsel's mind
Yes.
that her litigation conduct was not unreasonable.
Can I just put it slightly differently? I don't think. Are you submitting that whether or not litigation conduct is reprehensible, I suppose in some respects is a sort of comparative exercise, but I don't think you're submitting that the father's own behaviour or own conduct or him having made allegations that were found to be untrue might justify reprehensible behaviour by the mother. You're saying it's a balance. Is that right? You weren't seeking to say that they might justify reprehensible behaviour by the other parent.
No, my lord. At this
Sorry, I
stage,
just wanted to, because you just said then her litigation conduct is not reprehensible, as though there was a link.
I'm grateful for the clarification, my lord. Thank you. No, I'm saying that what might, when seen as isolated incidents, of behaviour seem unreasonable or reprehensible when seen in the wider context of what else was going on is not properly categorised in fact as unreasonable or reprehensible.
This was your first submission after lunch.
Yes, thank you. My lord.
Yes, thank you. Yes. And don't forget, we do have your very full skeleton, which sets out in detail your submissions. Effectively, as you said, the judge was aware of the law and applied the law in your submission correctly, and has a very wide discretion.
I'm grateful, and I know my lord has already referred to the hurdles that, with greatest respect, this court must cross
Yes.
before overturning the judge's decision. I'm not going to labour any of those points.
Thank you.
What I am going to move on to at this stage to say is that even if Recorder Samuel's King's Counsel had found no unreasonable conduct of the litigation or reprehensible conduct of the litigation, and the gateway was open to him, it was nonetheless then also open to him to make no order as to costs in the exercise of his discretion.
If he'd found it was a reprehensible, he didn't have to then make an order for costs.
Correct?
Yes, because it says it's a gateway, it's not a cliff.
Precisely so.
But that's not what happened here. And so you're not, are you going to be able to sustain a decision that was unsustainable by showing that he might have come to the same conclusion at a later stage?
And this is where, before lunch, I indicated to my lords, my lady, that I was inviting this court to read Recorder Samuel's judgment as in fact having done two things. Firstly, to say no unreasonable conduct, no unreasonable or reprehensible conduct. Alternatively, if there was, then the right exercise of my discretion is to make no order as to costs.
He clearly didn't do that, did he?
And this is where, my lord, I have to accept that that aspect of the judge's decision-making of how the circumstances of the case fed into...
I understand that, but Mr. Tadros, if, I mean, the appeal is against the order, Mr. Davis is inviting us to substitute, if we allow the appeal, a different order. So I think either way you can make these points, because even if they don't go to support the judge's decision, there are submissions you can make in the alternative as to why, if we do think the judge fell into error, we should nevertheless make no orders to costs.
I understand and I'm grateful. Thank you, my lord. Before leaving aside entirely the reading of Recorder Samuel's that I put forward, point again simply to the first sentence of paragraph 61.
Yes.
Where he refers to this being a case where he should exercise his discretion to, or
Yes.
should not exercise his discretion
Yes.
to make a costs order. That's what I say.
Well, I don't want to pause you here, but I mean, there isn't a respondent's notice in this case. But if it had been point 6 under 61 saying, even if I'd found it reprehensible, I wouldn't have made an order for costs for these reasons, then of course you'd be on solid ground in that respect. But I mean, in a sense, we'd have to invent that process, would we not?
My lord, I think that's where we differ with greatest respect.
Okay.
I invite the court to read 61 in the way I've identified and 62 in the distinguishing of other cases as putting this case differently from those within which unreasonable conduct has existed. But coming on to at least whether this court should exercise any such discretion and making, in effect, the same points. And pray and aid, really those same facts, those same findings, those same features of the case that I've pointed to as giving context to the mother's own conduct and behaviour.
Yes.
And that, in short, the judge was, or the right approach to the exercise of costs in such a case where both parties have been found to have lied to the court, where the court was not impressed with either of their presentations in their oral evidence. It's open and the right outcome to make no order as to costs.
And this is your general point about context and balance.
Precisely so, my lord.
Which you bring in both in support of your submission. The conduct should not be categorized as reprehensible or unreasonable, and even if that this is not a case in which the discretion should be exercised by the making of any order. Can I just ask? I should have. Mr. Davis said that he would invite this court, if we decided the judge's decision was flawed in some respect, to make the decision ourselves. Is that your submission as well?
My lord, the cogs will tick on slowly in response to that question. What it may be related to is a point I was about to make, which is that the exercise of discretion to make costs at this stage does appear different to the exercise of discretion on costs that, as was being presented before Recorder Samuel's KC. And I think this is the point I has clumsily started on my feet with, which is about the de minimis, the acceptance that any costs order would be de minimis. Recorder Samuel's King's Counsel made his decision on costs at a time when he thought the only impact on the mother's and ultimately the children's households' finances would be de minimis, and any meaningful recourse would be had against the Lord, would be sought against the Lord Chancellor. That position is now slightly different.
Was that not solved by making it not to be enforced without leave, if any such order were appropriate at all?
My lord,
I mean, clearly this court is not in a position to deal with any matters of enforcement, assessment, and there may be legal issues in relation to the interpretation of the statute and the regulations, but aren't all of those problems, as it were, dealt with by putting a stay on any order that might be made?
my lord, I can see that that would certainly address the potential of any immediate impact on the mother's household and finances, but it does.
It would mean that she would, on the face of it, not be likely to be called upon to pay anything that she couldn't afford to pay.
The impact, although perhaps not immediate, would still be to place a sword of Damocles, some description over the mother's and the children's households' finances, that this obligation does hang, to be enforced ultimately upon an application and endorsement of any judicial endorsement of any such application.
Yes, but I mean, if the order was rightly made, then so what? If the answer would be not to make an order because it wasn't rightly made.
I think the answer, if it's that if, my lord, if the order is rightly made, I say that question requires some consideration of the impact on the children's household of the making of such an order.
Let me see what could be included is even if I mean, this is speaking theoretically, also hypothetically, and I'm sure it's again a standard form of order, is subject to assessment of what amount, if any, the mother should be ordered to pay and of enforcement. without and not to be enforced without leave of the court. So both elements. That assessment is specifically of what amount, if any, your client should be ordered to pay. Because as I think we've would that not be a way of addressing your concern? It's appropriate to be addressed.
My lord. I think, my lords, it's my misunderstanding, I think, of how a subject to assessment decision on costs would sit alongside an order for costs of, say, some percentage, which, as I understand, is the order sought. It's not.
The order sought's 100%, but
Quite.
Failing that, it's 80.
So I don't understand that the order sought or that you're invited to make is subject to assessment.
Okay,
it's for a
thank you.
substantive sum.
Right. Thank you. Yes.
Forgive me, my lords, my lady.
Not at all.
Turning to the punchline, if I might, then, I said I would address paragraph 41 of my learned friend's skeleton argument.
Yes.
There will be some familiar ripostes as
Yeah,
we look at
yeah.
these individuals'
Yes.
examples. Starting with paragraph A, again, I'm bound by the findings of Recorder Samuel's KC about the mother's confirming to counsel that she could name individuals and then not naming them. She explained in her evidence to Recorder Samuel, which was ultimately not accepted, that she had not said that to counsel. The wasted exercise that's described there in the third line, I think, extends to a direction made at a hearing that was in any event taking place. Paragraph B, I think with respect, be better on firmer or a stronger point in civil proceedings with out the inquisitorial nature of Children Act proceedings. The bestiality example raised there, again, was something that the children themselves spoke about during their ABE interviews. Paragraph C, and indeed this will feature in a number of the other paragraphs as well, criticisms of the mother's evidence and approach to the evidence in court, I think with respect reflecting that those very same criticisms applied or were found to apply in relation to the father's own evidence.
Right.
That applies with respect to C, to paragraph E. In relation to D, the mother offered an explanation to Recorder Samuel's King's Counsel in that same paragraph of the fact-finding judgment that she was concerned about the eldest child's privacy. Paragraphs F and G, again, taking them together. Those same comments, evidence under oath was simply untrue, applies equally to the father in these proceedings.
Yes.
The same applies in respect to paragraph H.
Yes.
again, the court finding not simply that the father's allegations of domestic abuse were unsubstantiated, but that they were untruthful. Paragraph I, if I can just call it briefly the intention point, rather than revisiting all of those submissions. Paragraph J, again, the inquisitorial nature point, same as for subparagraph B. I can leave my submissions perhaps by reflecting on the fact that this court is faced in the middle of proceedings, where, as I say, very much remains in the balance, with an application for costs from a man who's found to have been abusive to the mother of his children, from that mother in circumstances where she and the children are reliant on benefits income in social housing, where he has been found to have been untruthful in both his allegations against the mother and his response to allegations from her.
Thank you. Do you have any questions?
Yes, I've got one thing to raise. No. You've kindly, between you, know that, you provided us with the mother and father case report.
From all credit due to Moylan and
Very
friend.
much. Save us having to go to that. Could I just check with you, because I understand there's a degree of unanimity between you about this.
Paragraph 70 and 71, if this is recorded DS,
Yes,
various
that's right.
cases.
If we go to 70, 71 and 74, which is the list of 10 propositions. As I understand it, the distinction between public and private that is raised in paragraph 70 is not one that you advocate for.
No.
Paragraph 74, the first 3 propositions are not in accordance with what we've heard from yourselves. There are various others, such as 8 and 9, which may not be in accordance with the submissions that we've been receiving.
No, it appears that with respect, DS King's Council has adopted or applied something akin to the re-J exception that my learned friend puts forward. I say that even within the confines of this judgment does sit slightly uncomfortably with paragraph 71, where he also talks about, at least generally, the need for some form of unreasonable conduct, and clearly thought that the Supreme Court case of Reety did have some application or relevance to circumstances.
But you, as my lord has identified, would disagree with quite a number of the propositions set out on paragraph 74.
With respect to Reety, yes.
Yes.
I would prenate those jurisprudential and policy points that have trotted through quite quickly before the lunchtime break.
Yes.
I think very many first instance decisions since Reety and Re-S, including my lords, Lord Justice Jackson in M and F and H, that have considered the law settled in respect of costs in children's proceedings, not just in public law proceedings, but also in private law proceedings, since those Supreme Court decisions.
You have circumstances quite often where private law proceedings become public law proceedings because there's a Section 37 direction, and then in comes the local authority, and so you have cases which are both.
Quite. I was tempted to mention, perhaps I ought to have, the situation perfectly envisageable, I would respectfully suggest, in public law proceedings where cross-allegations are made by the separated parents, not necessarily adopted by a local authority who instead offers an either-or analysis, as to what the right outcome is, depending on the findings. They might lean one way or the other, but in those circumstances, is that properly regarded as private law or
Yes.
fact-finding or public law fact-finding? It becomes very difficult.
Yes.
We've focused in our, I think, submissions and in the authorities in the bundle on those cases where it has been fact-finding in particular, but there are also very many examples. Miss Justice Henke's Re O, which was quoted before, Recorder Samuel's King's Counsel, is an appeal in private law proceedings where clearly she felt that the law in relation to private law appears was settled by Re T&S, albeit those were public law cases. And there are a number of other cases, albeit not in relation to fact-finding, where there's no distinction drawn between public and private law.
Thank you. Anything else?
No, thank you.
Thank you very much, Mr. Tedros. Yes, Mr. Davis.
I'm very grateful, my lords, my lady. Very few short points by way of reply, so long as the court is willing to hear them, of course. I did indeed, and I'm glad you found it, put a mother and a father before you, having started to feel a sinking dread of regret at not including it in the authorities bundle to start with as the hearing progressed. You have...
Rather useful having it, actually.
I'm glad, and I'm glad, therefore, that you do.
I think it's something that we may consider it appropriate to deal with as an authority that's out there, so to speak.
Well, I'm grateful for that indication, my lord. The point that we took out of it and why it was cited in such brief fashion by me is simply that this is a case which says Re T can be distinguished and it does not need to be followed at first instance, and that's the point I made to you. It is correct, you've already identified that what the learned judge then goes on to do is to create effectively a new test with his 10 irreducible principles. We do not support those or that test before you today, though, as an aside that I hope is not deemed out of order, it does speak volumes that in 2023 the Family Court is still struggling to identify the test on costs arising from private fact-finding proceedings.
There are a variety of ways of looking at that. I mean, one judgment from a deputy is not in itself evidence of a struggle.
I completely concede to that point, my lord. Working backwards through some of the points raised by my learned friend in his submissions, a few times it was said that this is a cost application in the middle of proceedings and there is still a future to be had and a way forwards. My inference that there's some regret about that. It was not the father's choice. He, of course, had to raise costs following the fact-finding hearing, otherwise the order would have been silent as to costs and that door would have forever been shut. Having raised the issue of costs, it was Recorder Samuels that issued the case management directions that brought this through to the conclusion.
Those paper directions?
They were, I think, discussed initially at a hearing, the hearing following the fact-finding, and then evolved through to the October hearing when it was decided. My memory now, my lord, but in fact, I think the original idea was that Recorder Samuels would determine this question on the papers, but it ended up being determined at the October
dispute
hearing.
Resolution hearing next month, is that?
I understand there is a hearing listed, my lord, yes.
Do we have a date for that? Could you remind us?
I'm afraid we don't have an exact date, my lord. I don't know if Friend knows it.
It's known.
The 15th.
Thank you
I
very
hear
much.
from the back, and I'm very grateful to...
The
17th. The 17th.
15th of March. Thank you.
My poor hearing. It was said to you, my learned friend, this is a very short point, that the very same criticisms that I level at the mother can be levelled back at the father. Whilst in some cases that is correct, it is not the case in all of the points. So one of them, at paragraph 4c of my skeleton argument, so 41 little c, I criticised the way, as the judge did, the learned judge, that the respondent mother produced 8 witness statements which became ever more detailed and elaborate, with instances and accounts repeated with further details added over time. My learned friend says the very same criticism applies to the father. That is not correct. Unless I am misreading the judgment, no equivalent criticism is levelled. He produced only 4 statements, and that is made clear at paragraph 124 of the fact-finding judgment with none of the additional explanation. There was significant focus by my learned friend on the question of belief and the idea, as I praise it, that belief is a shield to costs when one advances allegations within family proceedings. That is, we say, simply not correct. I suspect the court already has most of my points on this, but we would say quite strongly that whatever a party's belief, there is a separate duty on them to ensure that issues are narrowed, and that any allegation pursued to trial, i.e. a fact-finding hearing, is credible, supported by, at the very least, prima facie evidence, and carries with it a realistic prospect of success. I accept that to a certain degree that criticism can be levelled back at my client, but this is a point I make simply to target this idea of belief. Whatever a party's belief, their failure to reasonably limit their case, where the effect of that failure to limit is case-warping litigation, is poor conduct, and the belief is no shield. My lord raised a point about a parent recklessly making allegations, and that strikes at that as well, no matter the belief. It's also a point touched upon by Lady Justice Staunton in R&R, which is in the authorities bundle at page 45, where she says, at the very top of the page, it is said that it would be wrong to discourage parents. I'm so sorry.
Lady Justice.
Yes,
Staunton.
that's what confused me.
I'm so
It's
sorry,
Lord
Lord
Justice
Justice
Staunton.
Staunton. Lord Justice Staunton. I'm so
Sorry,
sorry.
no, it's all right. Yes, sorry, which?
I'm so sorry. The very top of page 45 of the authorities bundle.
Yes.
It is said that it would be wrong to discourage parents from putting their views before the court when they may well be helpful to the court. For my part, I am not sure that it would be wrong to discourage unreasonable parents from putting unreasonable views before the court, and one might elaborate upon that to say reckless views or reckless allegations or allegations without foundation. Many litigants litigate vexatiously, unreasonably, or indeed, as the current test is, or as we've discussed, potentially reprehensibly, on the basis of a belief. It's my point. I'm not directing you to authority on that, my lady and my lords, but it's one of the reasons, and you can take judicial notice of this, that section 9114 and indeed civil restraint orders exist. If belief was an absolute shield to any conduct in litigation, we would have significant problems indeed. You have the point. I will move on.
Just referred to the end of Justice Staunton's judgment, second last paragraph.
Yes, my lord.
Was that what you, did you refer to that a moment ago, or does that supplement what you've been saying to us?
I didn't take you to it.
No, you're right. Well,
my lord.
Well, at least in that judge's view, the question was whether the arguments were reasonable, not whether the litigant thought they were reasonable.
Well, quite indeed. Belief is not what not what the mother in this case makes it out to be.
That's the legal aid. That's the Legal Aid Act, though. He's referring to the Section 17 test, as it then was under the Legal Aid Act, and the statutory requirement that you have to determine how much is reasonable to pay, which would be the next stage.
No,
So-
no, this is about
The real point.
reasonable litigation conduct. It's the second last paragraph.
It's the overlap, yeah.
The real point has been argued before. That's
Yes.
that's not to do with.
Reasonable attitude for the father to take. Sorry.
I mean, I appreciate that, you know, that there are shadings and gradations of how you might express it, but you have some support there for the idea that one can be even genuine in one's beliefs, but if they're not reasonable, that may not help you.
Well, quite. It certainly isn't a shield to what becomes unreasonable conduct or what is unreasonable conduct. If it assists, my lords and my lady, R&R is the Court of Appeal case. And I know I've already briefly referred to it. It starts at Authorities Bundle, page 41. That contains the ratio of Hale, as she then was. That forms the oft-quoted basis for some of the principles that underpin cost neutrality in children proceedings. This is one of those Genesis cases, alongside London Borough of Sutton.
But it doesn't say anything that wasn't said before in Sutton and Gojkovic.
No, I agree with that, my lord. But what's happened since? Again, sorry to take through cases that aren't before you, but often either the court in judgment refers to the London Borough of Sutton and R&R, or R&R is.
Yes, I'm just making the point, seeing as we're looking at the development of this principle, that there are many cases of Lady Hales which, looking back on them, were seminal cases. This isn't one of them. This is just her approaching matters in the same way as had been approached in a number of previous decisions.
No, I agree.
As it seems to me.
No, it's certainly not making you law. I agree with that. It was raised by my lady a few times, this question of where did the learned judge's impression of the mother come from, and this point about her intentions. I'm not going to spend too long on this, because I agree with my own friend that we only have the four corners of the judgment. He made some submissions once that question was asked a second time about corroborating evidence, and it may have been my misunderstanding of his submissions, but for my part, I would just say the best that can be said about that observation and finding by the learned judge is that was his conclusion, having seen the mother's oral evidence. I don't think you can go any further than that, and certainly there's no corroborating findings that I would say tie or lead into it. There was a short submission when going through what was said to be the findings of Recorder Samuels against my client. I say said because one of them I fear was wrong, and it's not a criticism of the mother's team. There was a suggestion that there was an allegation of pressuring the mother for sex, and that was an allegation which was then found. My précis, my learned friend's submissions, that was not the allegation. The allegation against the father was of rape. That is clearly identified by Recorder Samuels at paragraph 4 of the fact-finding judgment. He dismissed the allegation of rape, and he is clear about that in his judgment. He did make a separate finding, as of course he was entitled to do, of pressure for sex, but it is not correct to say that that was the mother's case at the outset. My lord asked me, quite rightly, during my previous submissions, whether there is a case that I'm aware of that draws a demarcating line between reprehensibility and unreasonable conduct, and whether anything directs reprehensibility out of the procedural bubble when assessing behaviour for the purposes of cost. And I previously said, my lord, that I was not aware of one. Over the lunch break, I have been reminded quite rightly that I am, and it is Ries. And Ries is an authority which does seem to draw a line, though it is not fully explained. At Authorities Bundle, page 22. Before dealing with this, I make clear that we are not suggesting there should be two tests, or that there should be the ability to look outside of the conduct of the litigation. That's not part of our case. Our concern was more the different thresholds between reprehensibility and unreasonable conduct. But what is said at 30 in Ries is, are there circumstances other than reprehensible behaviour towards the child or unreasonable conduct of the proceedings which might justify a cost order in care proceedings? So what the Supreme Court there is direct the question of reprehensibility out towards the child and away from the conduct of the proceedings. As I say, that's not actually part of our case, but as you raised the question, I thought best...
It's a bit of an outlier, that.
It is an outlier.
It is an outlier, so far as I'm aware, my lord.
Passage in the Court of Appeal in Reed T, which suggests the absolute opposite.
Well, indeed, save my ladies, as you've raised that point, that as I noted previously, it is a feature of VS that it does in fact criticise RET and say certain parts of it should be abrogated or not read in the way that they were previously being read. You can see that in the following paragraph, where it said that RET was not necessarily intending to rule out the possibility there might be other circumstances in which an award of costs in care proceedings might be appropriate and just.
The point is this, is that we're not talking about welfare, we're talking about where the incidence of costs should lie.
Yes.
And so therefore it's natural that one looks to see how costs got to be incurred in the first place. And so that is referable to the litigation conduct, not to whatever might have happened outside the litigation.
I would say that's a very sensible interpretation, my lord, but I can't change the words of Ries, which specifically says reprehensible behaviour towards the child. It's very hard to put a gloss on that.
Yes, but I think conduct referable to the proceedings might, of course, be conduct that predates the commencement of the proceedings.
Absolutely.
So you can talk about conduct in relation to proceedings, either predate or postdates the commencement of proceedings, because they might have an impact on the course of the proceedings.
Well, no, I completely agree with that, my lord. And in fact, by chance, that ties me into a further short point I would make in reply, which is that an enormous amount of criticism has been levelled in my learned friend's submissions at my client in relation to how he has conducted himself within these proceedings. One of the reasons it's important not to set off allegations or issues between parties or to take the approach that my learned friend suggests is often where there is very serious litigation misconduct, as in this case, the tranche A allegations. The warping effect they have is to change the approach of the other party to the proceedings. And we do not know how the father might have approached this case if the tranche A issues had not been within the proceedings. So perhaps a subtle point, but one I think that is important to make.
Yes.
A significant amount of, well, some time was spent dealing with the other orders and applications made on the 8th of October hearing. And you have the full judgment, my lords and my lady. I simply make the short point, and I think you have already made it, in fact, that whatever else was applied for, dismissed or done at that hearing is not relevant. What happened in the 8th of October hearing, save for the cost judgment, does not impact the question of costs arising from a fact-finding process that ended in May 2024, and that's what the cost application strikes at. Unless I can assist you on any further issues, my lords, my lady.
No, thank you very much indeed.
Incredibly grateful.
Well, Mr. Davis, Mr. Tadros, thank you both very much for, if I might say so, your extremely thorough and comprehensive submissions. We are going to reserve our judgments. They will be sent to you in draft in due course for the limited purposes for which they're provided to you, and you know the consequences if they are used for other purposes. Just saying that so that everybody is aware of the position. Others, I'm sure you are aware, but everybody in court is aware. And I know I'm saying it rather elliptically, but you know what I mean. And we would expect that once you've received the judgments, you will be able to agree a draft order, but if not, we'll address any outstanding matters on paper. So thank you again, as I say, for your comprehensive submissions.